Hello, and welcome to episode 4 of Fire Away, an online question and answer show focused on the employment law issues that matter to you. My name is Stuart Rudner. I'm an employment lawyer and mediator, founder of Rudner Law, and most importantly, host of Fire Away. We'll be streaming every month online on the third Tuesday of the month, and in case you're interested, past episodes are always available on our YouTube channel, our Facebook page, and other platforms. Just a reminder, we're happy to take questions as we go. If you have any questions for us, feel free to post comments on Facebook or tweet them to @Rudner Law. So today in episode 4, I'm quite excited to be joined by Michael Mitchell. Michael Mitchell is currently a vice chair of the Labour Board in Ontario. For many years before that, he was a well-known and well-respected labor and employment lawyer, and he also has an active arbitration and mediation practice. So Michael, before I welcome you, the most important reason that Michael is here is he is one of the authors of the Changing Workplaces Review, an agenda for workplace rights, which of course, as many readers or viewers will know, led to Bill 148. Michael, thank you so much for joining me for episode 4.
It's great to be here. Thanks for the invitation.
I'm looking forward to the discussion, and I think this will be interesting for those of us who, live employment law day in and day out. Bill 148 has been the big news story for the last, shall we say, 6 months or so, and many people have referred to it as the most significant development in the employment standards legislation in Ontario, at least for the last several decades. So there were a lot of dramatic changes. Unfortunately, I think some of the media focus got shifted to things like the minimum wage hike, which was really a small part of it. There were a lot more changes in Bill 148 and many more to come. That got the focus, but there were a lot of other things that employers and employees need to be aware of. So what I was hoping we could do is just to start by having you explain to us, I guess, how you got involved in this project and what happened after you completed the report and leading up to Bill 148. I almost feel like I'm asking you how a bill becomes a law, but I was hoping you could take us through the process.
Well, it was a long process, and I had decided to leave my practice when I got the invitation from the provincial government to do this study with John Murray, which involved not only a review of Employment Standards Act, but also a review of the Labour Relations Act. And the focus was, so interesting. I really, and so different from what I had done in private practice, but so interesting from a policy point of view, I couldn't really turn it down. It was to look at the changing workplace. It wasn't to look at just the Employment Standards Act or just the Labour Relations Act, which is how other reviews had proceeded, but to look at them both and to use the point of departure as the changed workplace, but more importantly, the precarious state of work for a lot of vulnerable people. And while that wasn't the only focus, it was certainly the main focus of the review, and probably the kernel that underlay, most of the recommendations that we made.
So, and precarious employment has been talked about a lot, but maybe you can explain what do you mean when you talk about the precarious employment as a concern?
Well, we basically defined precarious employment and vulnerable workers based on a number of factors. It wasn't equivalent to contingent employment, because there are a lot of contingent people that are paid a lot of money for the contingencies and the uncertainty that they face. So it wasn't contingency, although there are many aspects of precarious work that involve a contingency, but it's not synonymous. Secondly, we looked at people, including many of those in full-time jobs, who were precarious because, for example, they didn't have a pension plan, so they had no means really to provide for their retirement, or they didn't have access to benefits, so they were missing a huge component of the social safety net that a lot of us enjoy. Or, they didn't have a union and they were essentially left to their own devices. But most importantly, we looked at income. So we had a couple of measures of lower income that we used, but we only, if you were a low income person, but you had a pension plan and you had benefits and that kind of thing, you weren't included. You needed to be missing one of those things in order for us to count you. Now, it was a rough approximation. It wasn't precise, but it worked out to about 30 to 32% of the working population of Ontario that came within that definition.
Within the definition of low income.
Of low income and not having a pension plan or not having access to benefits or being otherwise in some precarious state, so not having a pension plan or benefits was a proxy for being precarious.
Just so you know, this show actually is my pension plan, so hopefully we're going to get the viewership up significantly. What about things like, people said the Uberization of the workforce? Was that something that entered into your analysis as well?
Yeah, no, for sure. I mean, the impact of technology was a major feature of what we looked at, but we didn't use it to measure anything, but we certainly took it into account. And we took into account the huge growth in temporary employment or in non-standard employment. So the part of non-standard employment that didn't really grow over the years was part-time employment. It had stayed relatively steady. Like after 40 years of massive growth from the 50s to the 90s, it sort of stayed steady. But temporary employment had grown very quickly in about the last 20 years. And all facets of temporary employment, including contract work, temporary help agency work, all those kind of things. So Uberization or whatever it is of the workforce from that source was certainly something that we took into account.
Yeah, I mean, I'll tell you from my perspective, working with employment law, day in and day out, not a week goes by that I don't see people that are called, contractors that are employees in all but name. To me, this is the most significant epidemic we're seeing, and people on both sides of the fence, the worker and the organization, don't realize what the risks are that they're incurring, and often don't realize that the benefits they perceive aren't really there. But I know, and I hopefully we'll have a chance to talk about this. That is something that eventually found its way into Bill 148. But was that something that you spent some time looking at as well?
Yeah, we spent a long time looking at this issue, and in fact, the government didn't accept our full recommendations on it for reasons that I didn't agree with, and we say we didn't agree with it. But they did change in Bill 148 the major focus. I mean, it is now the onus is on the employer or on the provider of the person using the work of the provider, benefiting from the work of the provider, to demonstrate that the individual providing the service is not an employee. So the onus has changed, and that's very significant. And now it's an offense under the Act to say somebody or to treat somebody as a contractor when they're not. And that's also very significant. And the damages that employers can incur are really very large. I mean, vacation pay and statutory holiday pay together add up to a significant percentage. Overtime, minimum wage, all the other attributes that go with the minimum requirements under the Act can be very significant. And so employers are taking a pretty significant risk now, as opposed to prior to the legislation, in not treating people as employees when they are. And so I think this should make a big change in the workforce. This was a major target of the American Department of Labor for the years while the Obama administration was in power. And I think, regardless, I think of who's in political office in Ontario, it's likely to be a major focus here for years to come.
Yeah, well, I think that's true because, as I said, it is such an epidemic. And I think, like you said, employers were taking a significant risk. It's now even more significant. But individuals as well. I mean, I have this conversation all the time with clients, and we work with employees and employers, so I have it on both sides of the fence. Right. But I often have to explain to them that it's not just a matter of how do you want to be paid. That's not the question. The question is, what is the nature of the relationship? Are you joining this company as part of their team, as part of the organization, or are you truly in business for yourselves and providing services to them, just like a lawyer like I would or you would have in past days?
Right.
And they don't, a lot of people don't understand that if you want to be an independent contractor, then that means you're in business for yourself, which if that's the case is great, and there may be some tax benefits. But a lot of people also don't recognize that if they are truly contractors, they don't get the protections of the Employment Standards Act because they are not employees.
Right.
And so they're often quite happy to get some tax breaks, but then they realize that they don't get statutory holidays, don't get guaranteed vacation, they don't get overtime pay. And I mean, what I see usually when this becomes an issue is at the end of the relationship, because of course that contractor agreement says we can terminate on 14 days notice or 30 days notice perhaps. And I've seen this happen many times where someone works for an organization for 5, 10, 15 years, all of a sudden they are quote unquote let go. And instead of getting a hefty severance package as they've seen other people get, they get 30 days notice. Now all of a sudden they realize what they gave up by being a contractor.
Right, and now you're going to be able to go back 2 years, to collect 2 years worth of whatever it is you are owed. And plus all the penalties that the Ministry of Labor might impose through notices of contravention or other means, and including interest and other things and possible court prosecution. I mean, it really is significant, particularly if you've got a number of these people and they all turn out not to be independent contractors.
Mm-hmm.
Now, the one difference we had with the government is we said the government should enshrine dependent contractor status in the employment standards legislation like it is in the Labor Relations Act. And the government didn't do it. Their reasons for doing it aren't because they think dependent contractors aren't employees. The government simply took the view, the Ministry of Labor did, that dependent contractors are already covered as employees and they don't need the added protection and the added definitional language in the statute in order to catch them. So, the Uber situation has not raised itself yet that I'm aware of, but of course it has in California, it has in the UK, it has in other places, and they've not succeeded. Uber has not won in those jurisdictions. So it's a risk.
Yeah, well, and that's an interesting point. We've always talked about you're either an employee or a contractor, and of course, the case law in recent years has created this middle category of dependent contractor as opposed to independent contractor,
right.
Which I think a lot of people don't quite understand. But to your point, it's recognized by the courts. It's not defined, but I think the ministry may have one view, others may have different views. So it would have been helpful to clarify that for everyone.
Yeah, we thought so, but there was a lot of our advice that wasn't taken by the government. They took some, so we're happy enough with that. But there's a lot of room for disagreement in these areas, as you know.
Well, that's one of the things I was going to ask you about was the process. So the two of you prepared this report, and ultimately, of course, the government took that, adopted some of your suggestions, didn't adopt some, and then implemented some of their own that you didn't even suggest in your report.
Yes, that's right. I mean, and the thing I give the government full marks for isn't necessarily what they did, but in the process, they fully respected our independence. I mean, they did not give us an agenda. We weren't aware that they had an agenda. For example, the changes that they made to the minimum wage, $14 and $15, were a complete surprise to us. I mean, we found out about it at the same time that everybody else did.
Right.
And it didn't factor in our recommendations because we had no idea what they were planning to do. Now, of course, I mean, we treated them like they were, I think appropriately, as a stakeholder. I mean, the Ministry of Labor is certainly a stakeholder when it comes to employment standards, not so much under the Labor Relations Act. Mm-hmm. And so we listened to their views, and of course they knew what our intentions were, where we were going. They had drafts of the report to consider what they thought they should do, but they didn't ask us what our views were on their intentions or on the legislation. And so there was a complete separation of the two processes, and I think that was, in the end, probably completely appropriate, so that we were not subject to any pressure in terms of what our recommendations were.
Yeah, and I think that makes a lot of sense. A lot of people probably don't realize that the disconnect between your report and Bill 148, and then they're not the same thing in any way.
Right.
So one thing I wanted to ask you about, because when I reviewed the report, when it first came out, there's a quote in which you write, "In the course of this review, we have noted that there is a widespread lack of knowledge and understanding of workplace rights under both acts," which I think is absolutely true. And I see it day in and day out, again, on both sides, both employees and employers. And I know you made some recommendations in your report as to how to address this concern and increase awareness. And I think Bill 148 adopted some of those. But I was hoping you could talk a little bit about what mechanisms have been put in place to increase awareness, but also what else you'd like to see happen over the next, let's say, 5 years.
Yeah, I think it's the central problem of employment standards in our society is the lack of understanding, the lack of awareness, and the lack of compliance. And in some cases, they all go together. In some cases, they don't. I mean, some cases, employers just gain a competitive advantage by not observing the Employment Standards Act and not having a level playing field. And that's problematic. But there's probably just as much ignorance amongst employers and amongst employees. And it's odd. We spend so much time in workplaces, and yet people don't have a fundamental understanding of their rights. So we made, there are probably, Stuart, 20, 25 recommendations that we made to increase awareness. And the government perhaps only took into account a few of those. The major one they didn't do. The major one would have been to put all three acts, the Employment Standards, Labor Relations, Occupational Health and Safety, into one Workplace Rights Act, and to talk about workplace rights. And once people understood that there were rights that went along with being in a workplace, they would come to understand over time what those rights were and know that they had them, just as they do, not everybody knows exactly what their human rights are, but they know now, after years, that there's a human rights code and they have certain expectations. Yeah. And that expectation would come with the use of those words and that concept over years and years and decades, like even in 5 years. So I think it's a pity that they didn't do it. I don't think people understand what employment standards are. It's like an anachronistic term, from 50 years ago, which, has no place in my view going forward. Neither does occupational health and safety. Nobody knows what occupational health and safety is. Nobody knows what labor relations are.
No, I think you're absolutely right.
You have to use words that people understand as the starting point. But we had a lot of other recommendations, putting this in the high school curriculum, having the ministry do a lot of outreach programs, having the ministry do a lot of educational programs, and a host of other things to increase consciousness.
Yeah, no, I mean, I think that's critical. And I wrote a blog post probably about a couple of years ago now, which I think is still on our blog, suggesting somewhat facetiously, but not really, that there should be an Employment Standards 101 course for all new businesses or new business people.
Yes, right.
Because, I mean, and you've alluded to this, but, I see a lot of breaches of employment standards as well as other laws, and some of them are very definitely deliberate. On employers who just want to take their chances and hopefully cut some corners, save some costs. But for the most part, they're just inadvertent. And employers don't understand what the laws are. And they think they can do things like, say, as one employer said to me, years ago, well, so-and-so comes in every weekend and sort of catches up on his work. And I sort of hopefully asked if they were paying overtime. And the answer was, no, he's happy to do it. And knowing this employer as I did, he would have paid if he thought he had to. He just didn't think he had to. So there needs to be a lot more education. And as you said, they've adopted some of your suggestions, not others.
Right. Simplification was one of the major ones that we tried to stress, but that's very hard to do because life is complicated, work is complicated, the economy is complicated. And we're not going to get rid of the need for drafting and lawyers and all that kind of thing. But we could work at trying to simplify some elements of this and let simplification trump, I hate using that word these days, but trump, the desire to get every little complex thing dealt with. every little nuance addressed. Because, you know, when you try to do that, you wind up with a lot of complexity. And the Employment Standards Act starts to read like the Income Tax Act, and nobody gets that either. So.
No, that's a problem. I love the fact that within 2 minutes you mentioned getting rid of lawyers and also Trump. So that's very impressive. So I know we've only have about a minute left before I will have to let you go, but maybe I'll end with this question, Michael. What do you see as the biggest challenge that we're going to face in the workplace over the next 5 or 10 years?
I think the biggest challenge is enforcement. There's not going to be a fundamental change in consciousness and in practice amongst employees and employers unless there is proactive, strategic enforcement, unless the ministry kind of becomes the cop of the workplace, unless they change their whole approach to education and enforcement the way police services do or the way the Securities Commission does in regulating securities. I mean, they just have to take a much more activist approach to the whole thing. And if they don't do that, all of these changes are going to be for naught. So I see that as the biggest challenge facing any government in the next period of time.
Yeah, I agree with you completely. And, you know, just to my point earlier, I see a lot of employers that breach employment standards, some advertent, some inadvertent. But in many cases, they get away with it. And I mean, I still remember a client I worked with many years ago who almost prided himself on getting away with it. And in that case, it wasn't so much employment standards, it was more common law obligations for notice or severance. But the point is the same. There was no penalty, so no disincentive to breaching. Anyway, I think that does it for our time, Michael. But I want to thank you again. I was thrilled when I was told that you agreed to be on the show because I wanted to be able to talk to you and understand a bit more of the background behind Bill 148 in the report. So thank you once again. And I will mention for anyone who's interested in learning more about you, they can go to your website, which is www.cmichaelmitchell.com. And learn about your arbitration and mediation practice, as well as, I guess, your background as a labor and employment lawyer. But thank you so much for your time.
It was great to come on. It was a lot of fun. Thanks very much, Stuart.
Great. Well, thank you. And
okay.
I guess now we get to take a breath, and then I get my chance to fire away. What I wanted to talk about today is the Ministry of Labor and their role. And I'm thinking in particular of Ontario, but it's pretty much the same across the country in each jurisdiction. Every province has its own ministry, which deals with its own particular employment standards legislation, because of course in Canada, every jurisdiction has its own legislation. And in one of the issues that was identified in the lead up to Bill 148, one of the concerns was the lack of knowledge and understanding of employment standards legislation. So one thing I will say is employers and employees, everyone should be aware, the Ministry of Labor in Ontario and again across the country, they have great websites. The Ministry of Labor in Ontario particularly has an excellent website. It has guides, it has tools to help you understand the exceptions, which types of workers are governed by which regulations, which are not covered by which regulations, who gets overtime, who doesn't, etc. They have calculators, so if you need to understand how to calculate vacation pay, severance pay, etc. There's a lot of great tools on there, and you can also call them, and they will give you helpful information. My criticism, and what I want to talk about today, is the fact that the ministry will not make people aware of the limitations of the information that they are giving. And what do I mean by that? They will advise you with respect to the employment standards legislation. They will not provide you with advice regarding any of the other laws that will govern the employment relationship. And as I'm sure most viewers will know, the employment relationship in Ontario is governed by a multitude of laws: employment standards, occupational health and safety, human rights, privacy, labor law, the common law, contract law, and there's probably a few others I'm forgetting. So the challenge that we have as a ministry is advising you with respect to just one of those. And the best example is usually when it comes to termination of employment. So again, as many viewers will know, termination of employment is governed by employment standards legislation, which sets out the absolute minimum amounts people are entitled to, but it's not the end of the story. And the common law will provide that they may be entitled to substantially more notice or severance than the Employment Standards Act requires. So take the example, and I wrote this down before just to keep it clear in my head. Take an example of a 20-year sales employee who's 63 years old, working for a relatively small employer with a payroll of less than $2.5 million. If the employer had to let this individual go, perhaps because of a downturn in the economy or whatever reason they have, and they were to call the ministry or go on the ministry's website, the answer they would be given is that they have to give this person 8 weeks of notice or termination pay, period. That's it. Whereas the common law would say they are entitled to quote unquote reasonable notice, which takes into account length of service, age, the nature of the job, and anything else that's relevant. And although the common myth out there is 1 month per year, that's not the law. It's often not a bad estimate. So in this context, our 20-year employee is 63 years old. If the employer calls the ministry or goes on their website, they're going to be told to give him 8 weeks. And yet the reality is if they are entitled to common law reasonable notice, it's probably 18 or 20 months. So in this context, the employer may be breaching this individual's rights and giving them far less than they're entitled to without any intention of breaking the law. And if the individual wants to make sure they're getting everything that they're entitled to, and they're going to do the smart thing, they're going to call the ministry, and the ministry is going to tell them the same thing. You're entitled to 8 weeks, period. And they might walk away from 16 or 18 months of severance at a time when, in all likelihood, their career is ending. So this is something I've seen it happen time and time again. I still remember one situation I had years ago where I was advising an older couple who ran a restaurant in Toronto, and essentially it was very typical. The man was the cook, the woman was the one who served and took the payment for the check, and they got busy. They hired a waitress, things were going well, and then things slowed down, and they realized they had to get rid of the waitress and wanted to pay her fairly. So this older gentleman went to the University of Toronto Law Library. He found the Employment Standards Act. He dug it up. He checked what he owed this individual, found it was 2 weeks. It sounded really low to him, so he called the ministry. They said, yep, 2 weeks. He thought he was going to be nice, and he gave her 4 weeks. And next thing that happened was he got a very aggressive demand letter from her lawyer saying he owed her something more like 6 months. And that's when he contacted me. And I was the one who had to tell him that, yes, you did everything right, other than call a lawyer, which would have been the smartest thing to do. But you did everything right, and nevertheless, you now find yourself facing a lawsuit unless you pay some money to make this go away. So again, I can only encourage people to understand the Ministry of Labor provides information in a very narrow scope. So take advantage of that. Use the calculators, use the tools, call the helpline, but understand it doesn't cover all of your rights. And if you're an employer, you need to understand that just because the Ministry of Labor says you only have to do X doesn't mean that's all you have to do. As an employee, just because the Ministry of Labor says you are only entitled to X doesn't mean that's all you're entitled to. The other examples I'll give very quickly before I wrap up is things like probation period. There's this assumption out there that every employee has a probation period automatically when they start work. That's not the case. So even though the Employment Standards Act says you can be let go without notice in the first 90 days, again, the common law would say you have to get reasonable notice. And yet, if you call the ministry, they will say, no, you don't have to give any notice. Or temporary layoffs. There's this assumption as well that you can lay someone off temporarily if business slows down. It's in the Employment Standards Act as to how you can do it. But the Employment Standards Act doesn't give you the right to do it. That has to be in contract, or it can be implied in certain industries. So construction, we all know that, at certain times of year, people might be laid off. That's an implied term of their contract. But for the vast majority of employees, you can't be temporarily laid off unless that right is written directly into your contract. So again, I would just conclude by saying that it is critical that people understand there is information out there, and it's valuable information whether you go to the website or use the phone, but people need to understand that people need to understand the limits on that information, what it is covering and what it's not. And again, although it sounds self-serving, start with the Ministry of Labor, but contact an employment lawyer to make sure you understand your rights and your obligations before you take any action, or you'll find yourself either the subject of a lawsuit or leaving a whole lot of money on the table. So that's my time to fire away from today, my 2 cents worth, and you got it here for free. So what I would like to do now is once again thank Michael Mitchell for joining me on episode 4 of Fire Away. Really enjoyed the conversation. It was interesting to hear, one of the author's perspective on what happened with Bill 148. I hope that everyone will tune in again for the next episode. Again, it's the third Tuesday of the month, which next month will be on June 19th. And I'm going to be joined by Axis Geffen, who is the founder and president of Axis Bureau Incorporated. Axis is a top-notch investigator. I've worked with him many times. In fact, I spoke with him late last night on a file we're working on, and he will give us a scoop on how investigations work, what you need to know, and what you need to be aware of as you embark upon the process of an investigation, which is becoming a tremendous part of HR in Ontario and in Canada, especially in the Me Too era, and the need to investigate any allegation of harassment. A reminder, past episodes can be found on YouTube, on our website, and on Facebook. And if you like or subscribe to our channels, you'll get notifications when episodes are either posted or live. And I want to remind everyone as well that my firm and I strongly believe in education. We provide a lot of useful information out there, including our blog, including our social media feeds, including this show. So please sign up for those, including our newsletter, so you'll get all the reminders of everything we post. But lastly, please remember, none of that information replaces legal advice. And as I often say, if you think you might need an employment lawyer, you probably do. So feel free to reach out to us if you have a concern, and I'd be happy to talk to you and see if we can help. That's it for today. Thank you, Rob, for keeping us on track as usual. Thanks for tuning in, and have a great day.